Rick, do you want to give it a few more minutes or do you want to get started?
Oh, am I supposed to change the screen? I thought Matt was going to flip the screen when it was ready.
Oh, I don't know.
There we go. Okay. Well, welcome everybody. Sorry about the little bit of delay here. Of course, as always, there's going to be some kind of a technical issue, but everything's been squared away. Welcome, I'm Rick Jopik. I have the honor of introducing today's program. Before I get to that, though, I've been asked to kind of talk just a moment about some upcoming programs. As you see on your screen, we have the MDTC Legal Excellence Awards for 2022 coming up on March 17th at the Gem Theater. We also have what's new in 2022, the annual conference in person at Treetops Resort, June 16 and 17 of this year. Amazing, we're finally getting back to being live. If you need information or would like more information on those two programs, in your chat box, you'll see a link to the MDTC website, and you can go there and get more information, and hopefully we'll see you at both events. While I'm still on this screen, I wanted to thank our sponsors also, LCS Record Retrieval, Foster, Swift, Collins, and Smith PC, and near and dear to my heart, Kitch Attorneys and Counselors. Next, I would like to kind of introduce the program here. What we are going to listen to today is disqualified immunity, current trends in qualified immunity law. And this session is going to address the recent evolution of the doctrine of qualified immunity and identify trends in the decisions that are emerging from our trial and appellate courts on this issue. The session will additionally include discussion regarding recent changes and how our courts are analyzing constitutional challenges to police use of force. I would ask that all of you, if you have any questions through the program, that you use the Q&A link at the bottom of your screen, or you can submit them into the chat. Both Holly and I will be watching for those, and we'll get to your questions. If not during the program, at the end of the program, we'll try to get to as many as we can. Okay, well, with no further delay, let me introduce Holly Battersby from the firm of Rosati, Schultz, Jopik, and Amsbugler. I knew I was going to stumble over that one.
Did great.
Holly is a shareholder with the law firm of Rosati, Schultz at Paul, who specializes in defending governmental entities and their employees in a broad range of civil litigation arising under both state and federal law. Holly has appeared in courtrooms across the state on behalf of her municipal clients. Her areas of expertise include defense of constitutional law claims, including police civil rights actions, claims asserted against correctional facilities, and First Amendment claims, as well as state law tort claims related and arising under the proprietary function, public building, highway, and motor vehicle exceptions to governmental immunity. Holly has also represented her clients' interests in both the U.S. Sixth Circuit Court of Appeals and the Michigan Court of Appeals, obtaining reversals of unfavorable lower court decisions on behalf of the municipalities she represents. Well, with no further delay, and we welcome Holly, and I'll tell you just very quickly, Holly, almost 3 years ago now, volunteered to provide us with her knowledge and expertise in these areas for the annual conference back 2020 that we had to cancel. So I welcome Holly and thank you for being here for us, and I'll turn it over to you.
Thank you, Rick. I appreciate it. I'm going to pull up my PowerPoint here. So I, as Rick mentioned, practice exclusively in the area of municipal defense litigation. And in that arena, I primarily defend public officials, employees, police officers in actions that arise under 42 USC 1983. So where a plaintiff comes in and says, hey, this individual has violated my constitutional rights. And so we're in federal court primarily on those claims. And one of our defenses to these constitutional actions, and our best defense, is qualified immunity. If you've been awake and alive over the last 2 years, and Rick, it's funny that you mentioned that we had initially talked about a presentation 3 years ago, I think it would have been a much different presentation. If you've been awake and alive over the last 2 years, you've seen a call in the media for the abolition of qualified immunity. And activists who are making that call believe that it's necessary to have officers accountable for their actions. And they feel that the shield of qualified immunity is one that is encouraging corrupt behavior within the police forces. I think a lot of that is based on misinformation, and we'll talk through some of that as my presentation goes on today. But that's the basic issue in the media. Does qualified immunity foster an environment of corrupt police behavior? And so I think we need to start and understand kind of just the basics of qualified immunity to start. Qualified immunity was, in its current iteration, introduced in a case called Harlow v. Fitzgerald back in 1982. And it was designed so that officers, governmental employees, were shielded from liability so long as A, they were acting in their official capacity, and B, they weren't violating clearly established constitutional or statutory rights of which a reasonable person would have known. So if an officer reasonably believes that his or her conduct complies with the law, the principles of qualified immunity should shield those constitutional claims that we see coming in. One case that we love to cite as defense attorneys is that qualified immunity is so broad and such a shield that it should protect all but the plainly incompetent or those who knowingly violate the law. And so you heard the words clearly established. So the right has to be clearly established in order for an officer to be subject to liability. And those words have become, over the years, the subject of many, many court decisions. But the basic premise is that the officer has to be on notice that his or her conduct is violating the Constitution. And the way that these officers are on notice, typically, is because there's some Supreme Court case law or some Sixth Circuit case law that tells them, within a certain degree of specificity, your actions in this context are objectively unreasonable. The contours of the right are supposed to be spelled out for these officers and governmental employees within the relevant case law so that it's clear to them that what they're doing would violate someone's constitutional rights. And the courts tend, in our circuit and the Supreme Court, to get pretty specific on the types of cases that they will hold demonstrate clearly established law. So the unlawfulness has to be apparent from direct holdings, from specific examples, or from the general reasoning that the court might set forth in its opinions. When conduct is within what we call the hazy border of a constitutional right, it cannot be said that it is a violation of a clearly established constitutional right. The logic is that the existing precedent is supposed to have put the officer on notice that his conduct would be unconstitutional beyond debate. So it's a pretty difficult standard in some circumstances for plaintiffs to overcome. And I can give you an example of how this sort of plays out in barring litigation or a lawsuit from going further by a plaintiff. I had a case recently where there was a jail injury, and a woman was driving at a 0.357 BAC, which is a pretty astounding level. And she was doing quite well until she clipped a mailbox and caught the attention of another motorist in the area. And after her arrest, the officers gave her a PBT. In fact, they gave her two because they assumed that their machine was broken after it registered a 0.34 something. And she was transported to the hospital because the officers had concern for her medical condition because they had never quite seen a blood alcohol content that high. She was coherent. The doctor examined her and noted in a medical record that she was alert and oriented ×3. She was able to make her own medical decisions. She was filling out paperwork. She was able to walk in and out of the hospital by herself. So he medically cleared her for lodging. He did not keep her overnight at the hospital for observation. He told the deputy she's good to go. The deputy had been observing her for a number of hours and really did not see any behavior on her part that would have caused him to be concerned for her medical condition. They get to the jail and she's able to get out of the police vehicle. She's handcuffed behind her back. She's able to do that by herself. She's able to shimmy through a pretty tight space between the door to the police vehicle and the Sally Port wall. And she goes into the interior of the jail. The officer is walking beside her, and I'm going to show you some video that the surveillance cameras in the jail caught. And you can see her walking through this door with the deputy by her side. Here she comes. And he doesn't have a hand on her to assist her. She's doing quite well on her own. She kind of does a stutter step here and there. But she's able to maneuver through the hallway by herself. The deputy walks up these 2 steps, which is what you just saw, and he's going to buzz her into the interior of the jail so that she can be booked. He had his back to her. He did not expect her to follow him up the stairs. His testimony is that he was once allowed entry into the door. He was going to go back for her. But unbeknownst to him, she followed him up the stairs, and you'll see that her injury was caught on the camera. Here she goes. She's walking up the steps.
Holly,
And yes.
I really hate to interrupt.
No, sure, Rick.
Your screen is not sharing.
Oh,
on the
no.
program.
Okay, let's see if we can fix that.
Okay,
Thank you so much for telling me.
sure.
Can you see the screen now?
Yes.
Okay. Okay. So
There
I'm
we
gonna all right, I'm gonna replay this video.
We got excited by a video. and
Yeah, I know. I
wanted
was
to see
excited
it.
to put the video in, so I'm really glad you stopped me. So you can see that she's walking down the hallway. The deputy's behind her. She's doing pretty well on her own, a little uncoordinated, but not doing too badly. Here's where he goes up the 2 steps. You kind of lose sight of him for a second. She follows him up and, like a sack of potatoes, falls to the ground. She has no recollection of the incident, and the deputy didn't see why she fell. It was likely because she blacked out or had a seizure due to the high blood alcohol content. But in any event, it was a very serious injury, traumatic brain injury that prevented her from working and really affected her lifestyle, if you believe her testimony. And so her attorneys filed a lawsuit in the Eastern District pursuant to 42 USC 1983, alleging that this deputy was deliberately indifferent to a substantial risk of serious harm to her because he failed to assist her as she moved through the jail. The plaintiff would have preferred that he put an arm on her elbow or otherwise assisted her through the jail to ensure that nothing bad would happen to her. We asserted, amongst other defenses, the defense of qualified immunity because this deputy reasonably believed that his conduct complied with the law. She had been released by a medical provider who told him that she was safe for transport and lodging, and he did not observe any conduct that would have put him on notice that she was experiencing a medical emergency or was subjected to a risk of serious harm inside the jail. We also pitched the clearly established angle and said, even if a violation did exist, there's no case law within our circuit or the Supreme Court, which is on all fours with the facts of this case, such that this officer would have been on notice that he was violating a clearly established right. The trial court disagreed with us and dismissed the case or denied our motion for summary judgment based on qualified immunity. And so I took it up to the Sixth Circuit. And the primary argument there was this clearly established element, because the plaintiff couldn't point to any case law in our circuit other than generalized case law that talks about the amount of care you're supposed to afford prisoners. And the trial court relied actually on an unpublished out-of-state district court opinion. And we argued that that was not sufficient to put an officer on notice that he was violating a clearly established right. And we were able to get a reversal in the Sixth Circuit. The Sixth Circuit said there's two aspects to qualified immunity that the district court misunderstood or misapplied. Law is clearly established if it's within this circuit or the Supreme Court. And it has to be particularized to the facts of the case. So it's not sufficient to say there's a case out there that says that you cannot be deliberately indifferent to a prisoner's a substantial risk of harm to a prisoner. That's too general. You need something closer. You need a very intoxicated individual inside the jail who is alleging that an officer should have assisted her in order to avoid injury. And the plaintiff couldn't come up with anything similar enough, and neither could the Sixth Circuit. So we were able to get a reversal and a dismissal of the officer. So that's kind of how the clearly established element plays out in practice. So what's been going on for the past 2 years and even longer, but just not in the media, is that we have activists who believe, as I mentioned, that qualified immunity is a huge problem because it encourages officers to commit bad acts because they know they won't be held accountable. So I'm sure you've seen images like these all over your TV screens and the internet. So what is the true debate? Who's supporting qualified immunity? Who's against it? And what are they saying? Proponents, largely those in government and law enforcement, are pointing out that government employees, and in particular police officers, have extremely difficult jobs. They perform tasks which benefit the entire public, and those jobs require, especially in the context of law enforcement, split-second decision-making under conditions which are stressful, fluid, and unpredictable. And so if we take away the qualified immunity, police officers may hesitate when they need to actually act quickly. We also hear in the pro camp that, look, these employees and officials and police officers don't have absolute immunity. It is still possible to sue a police officer for misconduct. There was a recent statistic that came out. In 57% of the cases where qualified immunity is asserted, it's granted and the case is dismissed. But that leaves 43% where the case is permitted to proceed. So it's certainly not this absolute bar that sometimes is portrayed in the media, where it's impossible to sue a police officer based on a constitutional violation. The proponents of qualified immunity also argue that public officials and employees in the police will constantly be defending unwarranted lawsuits if there's not some kind of screen. And then they'll be subject to the judges and juries second guessing their split second decisions, especially in cases like use of force. Not only is this stressful and distracting for the individual employee who's being sued, but this is going to lead to significant costs for municipalities. essentially, the proponents are arguing that in the governmental context, especially law enforcement, employees have to have room to make mistakes or have moments of bad judgment, because otherwise we won't have police officers. And if you have any contact with law enforcement as a client or otherwise, you know that across the nation there are shortages in staffing. And so proponents really feel that if we take away qualified immunity, that those currently employed may quit. It's already a tough job, and this just might drive a lot of officers out. But also it will deter future officers from ever attending police academies and seeking jobs in law enforcement. But then, of course, there are many who seek the end of qualified immunity. And these are the people that you hear mostly about on the news. And their opinion is that the officers must be held accountable for all actions, regardless of whether it was reasonable or clearly established. Some seek to just chip away at the doctrine a bit and make it tougher for the officers to get out on qualified immunity. There's kind of a spectrum here. There are a lot of extremists who put out there that it's impossible for for plaintiffs to obtain justice for constitutional violations because of the doctrine. The proponents of the abolition of qualified immunity also argue that there's such inconsistency in the courts, and it's really dependent on what kind of judge you get. And a court can almost always manufacture a factual distinction with another case such that the current case could not present clearly established constitutional violations. So how have the Sixth Circuit and the Supreme Court responded? Over the last couple of years, my colleagues and I have been biting our nails trying to figure out what the public outcry was going to do to the judicial opinions that we receive. And we've been monitoring closely the opinions that are coming out of the Eastern District, the Sixth Circuit, and the Supreme Court to try to get a roadmap and try to determine whether qualified immunity is here to stay. There have been many favorable decisions that have come out of the Sixth Circuit in the last couple of years, which has been relieving to see. It's always a mixed bag in the Sixth Circuit. It largely depends on which three panel judges you draw. Some, when we see their names, we know that we're either going to get a dissent or a bad opinion altogether in challenging denial of qualified immunity. There was a case recently that received a lot of public attention. It came in and was decided at the end of 2021, so pretty recently. And the qualified immunity was afforded to an officer in a deadly force situation. So I have another video that, Rick, can you see this one? All right. So these are not my commentary in the writing. This is somebody who posted on YouTube, but this officer is making a traffic stop. And you can see the motorist flees. So the officer, because of the congested traffic situation, is not able to find him initially. In about 15 minutes, 30 minutes pass, and the officer goes back to the White Castle and spots him in the drive-thru. So he pulls in to block him with his police vehicle, and then gets out of his car with his gun drawn and approaches the driver's side. And we have some video from the surveillance camera inside the drive-thru. The guy in the yellow shirt is the fleeing motorist. And you can see on the left of your screen, the officer approaches him, and the plaintiff backs up and is threatening to use his car as a weapon against the officer. He in fact hits the officer's police vehicle there. The officer shoots 3 or 4 times, and it was a fatality. He flees initially, but he ends up passing out, they believe, because of his injuries. And you can see here, the officer's trying to chase him. And he crashes into an oncoming minivan. In the Eastern District, qualified immunity was denied. The judge found that it was clearly established pursuant to Latitz v. Phillips that the officer's use of force was excessive in this context. It was appealed to the Sixth Circuit, and the clearly established argument saves the day again. The estate couldn't find a case that would satisfy the Sixth Circuit as sufficiently factually analogous to put the officer on notice that his conduct was unlawful. The court held generally, when in a deadly force situation, if somebody's fleeing and leaves an officer or the public in a position of safety, that deadly force is not appropriate. But where the officer's prior interaction with the driver suggests that he's going to endanger others with his motor vehicle, the officer can use deadly force to stop the fleeing motorist. So it was a great decision out of the Sixth Circuit and gives us hope that we're not carving away at qualified immunity. This is very much how things looked prior to the public outcry for the abolition of the doctrine. And we've seen kind of this sea of some denials, some granting of qualified immunity in the last year. Qualified immunity was denied where even out of circuit case law talked about the particular right. So, you know, an unfavorable decision for us and a kind of a novel one. You know, certainly suggesting that those who argue that qualified immunity bars all lawsuits, you know, this case is good proof that that's not true. That's Rhodes v. Michigan. Browning v. Edmondson, again, qualified immunity was denied, where the court found that a woman had a right not to be tased while she wasn't actively resisting. Makes sense, but you know, there are decisions that deprive officers of qualified immunity and allow a plaintiff to proceed with a constitutional claim. Another denial that took place with regard to a sexual assault, Sexton versus Cernuto. Kind of running through here pretty quickly because I'm a little behind on time, but you know, sometimes we'll get a mixed bag where we have some claims stick around, some defendants stick around, but others dismissed. And Ricks versus Potch is a good example of that. These are all, like I said, very recent opinions out of the Sixth Circuit, which suggests that certain panels are not afraid to award qualified immunity, but it really depends on who you get. And then we look at the Supreme Court, and of course, Justice Breyer is on his way out, and we'll see a new justice most likely if she's confirmed. So some question mark there, but the decisions out of the Supreme Court, the two most recent decisions have been very favorable. So where we were worried that the Supreme Court might act to limit or abolish qualified immunity, we have not seen that be the case so far. So in October of 2021, I believe it was on the same day, the Supreme Court issued two qualified immunity decisions and declined to narrow the scope. So the first one, Rivas Villegas versus Cortes Luna, it involved a 911 call from plaintiff's girlfriend saying that the plaintiff was going to harm her and her kids. And so the police arrive, they tell the plaintiff to leave the house. He comes out with his hands up, but the officer saw that he had a knife in his left pocket. He lowered his hands, he did not resist, but he did lower his hands, and they started shooting him with some beanbag rounds. He got down on the ground, and in order to effectuate the arrest, the officer placed a knee on his back. And obviously, anytime we have pressure on someone who's, you know, either in the prone position or on their backs on the ground, we are worried that the court's going to apply extra scrutiny to that because of George Floyd's death. But in this case, the officer put a knee on plaintiff's back for about 8 seconds. The plaintiff alleged significant injury as a result of that. But the court said in the Ninth Circuit that there was existing case law that put the officer on notice that this was excessive force. So they denied in the Ninth Circuit, they reversed the lower court who had dismissed it. And then so it goes up to the US Supreme Court. And the Supreme Court ruled that the two cases which were being compared, Lalonde was the case that the plaintiffs were trying to say put the officer on notice that he was violating a clearly established right. The Supreme Court really looked at it carefully and required more specificity and more similarities with the facts and did not agree that that was clearly established. In Lalonde, they found that the officer or the plaintiff in that case was not armed and was only the subject of a noise complaint as opposed to threatened physical violence. So the court ruled that it really wasn't on all fours with what was going on in Rivas Villegas and granted immunity to these officers. So that's an indication to us that things are, qualified immunity is alive and well in the Supreme Court. And we have another case that came out, like I said, right around the same time. I think it was the same day, City of Tulacqua versus Bond. In that case, this was a deadly force situation. A man's ex-wife called police saying that he was in her garage and told them that it was going to get ugly real quick. The officers arrived and found the man in the garage. He was fidgeting and appeared nervous, which heightened their suspicion right away. After refusing a pat down, he walks over to his workbench, grabs a hammer despite the officers instructing him to stop, and brings it above his head, standing as if he's either going to throw the hammer or charge the officers, but certainly physically threatening the officers. And in response, two of the officers fired their weapons and killed the man. A Fourth Amendment claim was filed in the Eastern District of Oklahoma. The district court granted defendants motion for summary judgment, but then the 10th Circuit reversed. The plaintiff filed a petition for writ of certiorari to the Supreme Court. And again, we all kind of waited around to see if the Supreme Court would address the issue that the plaintiff raised in the court below, that the officers had actually created this situation which required deadly force by cornering the man and approaching him in an aggressive manner, so that when they used deadly force against him in the situation that they had created, it was violative of the Fourth Amendment where it wouldn't otherwise be. We thought maybe the court was going to address that issue because it's one that plaintiffs are raising more and more. You've probably heard the term de-escalation. The plaintiffs in our 1983 cases, really during deposition questioning and in the motion for summary judgment, are arguing that these officers need to come on scene and diffuse the situation rather than escalate it. And where force is used, it's because of the actions of the officer and should be subject to civil liability in the constitutional context. But the court ended up passing on that issue. It jumped to the second part of the qualified immunity analysis directly and said that there was really no case law on all fours with what happened in the case. And so it dismissed the lawsuit based on the clearly established analysis. It really focused on the specificity necessary, and this just didn't hit the mark. So again, another great opinion that leaves qualified immunity essentially untouched. So we have not really seen too much from the courts with regard to an evisceration or abolition of qualified immunity. It's been left largely intact. The Sixth Circuit is not afraid, in large part, to grant qualified immunity to officers if the circumstances warrant it. The same goes for the Eastern District, and I didn't really directly address the Eastern District up to this point. It really is judge specific. And like one of the opinions indicated, I'm sorry, as the proponents of abolition indicate, you really do see judges, especially when it is just a single judge, a district court judge, sometimes trying to get to the right result out of a fairness and justice consideration. And so that clearly established analysis tends to allow for that, because it really is up to the judge whether the facts are sufficiently analogous. And we see some wild shifts from case to case, even within the same judge. But you can rest assured, for now, qualified immunity is safe. We haven't seen any major shifts, and we continue to monitor. But we believe that the doctrine will be around. We may see some changes to it. But for now, we think we're in a good position from the defense standpoint. I don't know if there are any questions from the group.
I haven't seen any come in, Holly.
Okay, I was just checking the chat, and I think everyone was trying to tell me that my video wasn't working there. Yeah, I don't see any in there either.
But if anybody has a question for Holly, I would say type it now or forever hold your peace. I see none coming in, Holly.
Thank you, Rick.
Yeah,
My
no.
pleasure.
I saw. Oh, okay. We did get a chat, but
Thank you.
thank you so much for doing this for us. And for those who are in attendance, this was recorded. It's going to be posted, if not already, on YouTube and available for anybody to review after the fact. And certainly will be available to our members to view it as they see fit.
Thank you for having me.
You bet. Thank you.
Take care.